I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are back in Judge David Wolf's courtroom out of the state of Tennessee for part two and the final part to the trial of sovereign citizen Shereek Vaughn. Actually, his second trial that we've covered. And this is going to be the finale for this second trial. If you haven't seen the first trial in its entirety, I will leave a link in the description for you. And I also will leave a link in the description for you for the first part of this trial. I don't want to spoil anything that happened in the last trial or what happened previous to this second part. I encourage you to go watch it because definitely both of these trials have been very interesting. Mr. Vaughn obviously going pro se. I felt he did pretty well in that in the first part of this trial. So I'm interested in seeing what he does now that he's able to call some of his own witnesses. So listen, guys, it's about that time. Let's go ahead and jump back into this trial.
All right, thank you, ladies and gentlemen. The state has rested. Mr. Vaughn, do you wish to offer any witnesses or proof?
Yes, Jennifer Dozier, please.
All right. Ms. Dozier, if you'll come up, please. Raise your right hand and be placed under oath. All right, Mr. Vaughn, it's your witness, so you may question the witness.
Yes, sir.
Vaughn, you may ask.
Okay. How are you doing?
I'm okay.
Okay. For the courts, would you tell them how you know me?
You are the father of my kids. We've been together on and off for 20 years.
Okay. Are we together now?
Not currently, no.
How long have we been separated this time?
A little over a year.
Okay. You mad at me or something?
No.
Reason I'm asking, do you have a reason to be vengeful, or you want to
I-
answer truthfully here today?
Truthfully, I just didn't agree with. We didn't see eye to eye on things.
That's irrelevant.
Hookups?
We didn't agree with our lifestyles.
Okay. Okay. Do you recall what we stopped at the Exxon for that night?
Can of dip.
Did I get that can of dip?
No, you did not. That was most expensive can of dip.
I didn't get the can of dip.
No, you didn't.
Oh, darn. Have you been inside the Exxon before?
Yes.
Um, how many doors are there in the Exxon?
There is a door directly in the front of the Exxon, and then a door that conjoins with the crystals, and they actually have a door in the front as well.
Okay, so there's multiple entrances and exits into the Exxon.
Yes.
Okay. Did you witness anyone threatening anyone that night?
Well, no, I didn't witness the threatening. Or any
Did you?
threatening.
Man, put the microphone
All right.
right up against your mouth there and
What?
speak loudly, please.
Okay. Did you witness anyone threatening anyone that night?
No, I did not.
Okay. Did you witness anyone being hit?
No, I did not.
Okay. Didn't you witness anyone else present at the scene when we were at the Exxon?
No, there wasn't a lot of people at the Exxon.
Not a lot of witnesses. Okay. When we left the Exxon, did we leave in a hurry or?
No.
Okay. Where did we park at the Exxon when we was there?
It seems like you parked right in front of the store.
Is this my normal place to park?
Yeah. Everywhere.
What do you mean by everywhere?
Oh, come on.
For the courts, please.
You just, yeah, you don't like parking and having to walk, so you park right on the store, like right at the store every time.
Okay. So when we left the Exxon, was it any? We weren't running from anything, were we?
No.
Where did we go when we left the Exxon?
2 businesses down to the advanced auto park.
Would you believe that I was irate that night when I was driving away from Exxon?
No, I think you were actually kind of laughing a little bit.
Okay. What did we do when we got to advanced auto parts?
We went in and got a car part for our boss's derby car.
Okay. How would you say my attitude was then?
Fine.
Did you see my attitude change at any time during that night? Okay. When did we have a altercation, or let's say, not altercation, but the word I'm looking for? When did we make first contact with the officers?
The officers at Advanced Auto, after we were already in the store getting the part.
Okay, so we didn't run into the officers basically until we exit the store.
Yes.
Okay. Do you know a Miss Bethany Page?
No, I do not.
How often would you say that I went to Exxon?
Not often. It wasn't a regular store.
Okay. Would you state what side of the town our regular store would be?
Pomona,
Pomona. Why would that be our regular store?
because that's where we lived.
Okay.
For 20 years almost.
Okay. And you don't know Bethany Page?
I do not.
She don't know you?
Not to my knowledge.
Would you be able to pick her out if you've seen her?
Absolutely not.
Do you believe, to the best of your knowledge, that I know a Miss Bethany Page?
Not to my knowledge, no.
That I'd be able to pick her out if I ever seen her?
Not that I'm aware of.
Okay. Let me see. Is there any more questions for you? Did I exit the store with anybody? Did you see anybody at the store?
No, I mean, she came out right after you.
She came out of the
She
store?
did come out after you, yes.
Did you see her body language or anything?
It seems like she was kind of yelling a little bit, and you kind of laughed at it.
Okay.
Oh, well.
Do you feel like she was scared?
No.
Okay. Did you see her with a phone or anything in her hand?
No, I wasn't looking really at her hands.
How long would you say that the time lapsed from the time we was at the Exxon to Advanced Auto Parts?
Couple minutes, if that.
Okay. Would you believe that someone that wants to harm somebody would go next door to Advanced Auto Parts?
It doesn't seem very smart.
Do you believe that my actions that night were to do anything to get a part, but get a part for a derby car?
No.
Okay. I think that's all my questions I have, Your Honor.
All right, General Bryson, you may cross-examine the witness.
Did you get out of the store at the Exxon?
No,
Or did you
ma'am.
get out of the car at the Exxon?
No, ma'am, I was in the car,
Okay. What were you doing in the car?
just waiting.
Scrolling your phone?
No, just waiting, just sitting there, you know.
Were you paying extra attention to what was going on in the store?
Whenever I seen him come out and then her come out, that's when I noticed, like, hey, you know, and then she said, oh, she said she was scared. Why would you follow him out of the store if you're that scared? I'm gonna call the police. I'm not gonna
So
go out.
you didn't look, you didn't pay any attention until they both came out of the store?
Yeah.
Okay. And you would call the police if you were scared?
Yes, absolutely. I wouldn't go out with him. I'd be like, go out the door, lock it.
Okay. Did you observe if any other customers came in and out?
Not to my knowledge, no. I didn't
Okay.
see anyone.
Were you staring out the front window, watching
Yeah,
traffic?
well, he parked kind of like facing the auto parts store, like straight in front of the store with the front towards Crystal's. So when he come
Okay.
out, I seen that because I was in the passenger seat.
So when he pulled up to the store, you're in the passenger seat.
Mm-hmm.
Was the passenger seat beside the gas station or the driver's seat beside the gas station?
The passenger seat,
And I say gas station,
the front
not
door.
the pumps, but
Yes,
the
ma'am.
building.
It
Okay.
was mine, the passenger.
Have you ever heard Mr. Vaughn yell?
I'm with him on and off 20 years. I've heard him yell.
He can get pretty loud,
He
can't
can. Any people don't know how to take him.
Okay. Nothing further, Judge.
You redirect?
Yes, sir. You stated that you were in the vehicle,
I was.
and the vehicle was pointed towards Advanced Auto Parts Crystal's direction, correct?
Yes.
Would you say your door, the passenger door of the vehicle, would you say it was directly in front of the Exxon door?
Pretty close.
All right, here's a real good question for you. So why did I go to the Exxon?
For dip.
And I went into the Exxon. How long would you say that I was in there?
Couple minutes.
Did you see which direction I went when I went in the Exxon?
And went around the back of the vehicle.
No, I'm talking about when I entered the store.
Oh, I don't remember that part. I'm sorry.
Okay, you couldn't see the counter?
No, I wasn't paying attention to the counter, to be honest. I mean, you don't pull up at the store and expect, you know.
Would you say I was in the store just 10 minutes, maybe?
No, it wasn't even 10 minutes.
15 minutes?
No, maybe 5 to 7 minutes.
Did I exit the store with anything?
I don't remember. I don't think you did.
Okay, let's see. That's all, Your Honor.
Recross?
You knew that the defendant went into the store to get dip
Yes.
and that he came out of the store without dip.
Well, I seen him coming out and her coming out behind. Because at that point, I kind of heard a little bit. And I was like, doing over there, you know. So
What'd you hear?
I don't remember. This has been years ago. I just heard her screaming and he was kind of chuckling and coming around the bar. I don't remember what was said. I don't.
Did you ask why he didn't buy dip?
Yeah, and we had discussed it. And
What did he tell you?
he got into an argument because Miss Bethany thought that she knew me and apparently wanted to fight me. So he was trying to stop her from coming out to have an altercation with me.
Okay. Nothing further, Judge. Did you know Bethany?
I did not. It was a very bad case of misidentification.
Did you think you knew her that night?
I thought I knew her from school and from younger days.
What did you think her name was?
Jessica,
Nothing further, Judge.
Go on.
The state seems to want to have the court believe that I went to the Exxon for a Jessica. Would you say that I went to,
Let me rule on the objection. Sustain the objection. You're making a statement rather than a question.
let me rephrase it for you. Did I go to the Exxon looking for a Jessica?
no, you did not.
Do I know a Jessica?
Your cousin's wife, but I don't think that one matters.
That works at the Exxon, I could say.
Not to my knowledge.
So I went to the Exxon for what?
Dip, strictly dip.
Did I go looking for trouble?
No,
Do I know anybody that works at the Exxon?
no,
Did I give any indication that I wanted to go to Exxon for trouble?
no.
You stated that she followed me out the store.
Yes, you did.
What would you think the reason for her following me out the store would be?
Anger?
Sustained.
You said, what was she doing out the store?
Be the
Yelling.
same. Are you asking what actions she was doing
Yeah,
outside?
yeah,
I mean, I just seen like the yelling and the hand motions.
okay. No police showed up at this time?
Not at the store, no.
Was the police called at this time, that your knowledge?
No, they were not.
Okay. That's all I have, Your Honor.
General Bryson, you have recalls. Thank you, ma'am. You may step down. Mr. Vaughn, you may call your next witness. Ladies and gentlemen, step across the way just for a moment, please. Vaughn, you need to let the court know whether or not you plan to testify or not so that I can conduct what we call the Momon hearing as to whether or not you wish to testify. Come up to the podium. Come to the podium, please. Raise your right hand and be placed under oath.
I just affirmed.
Mr. Vaughn, do you understand you have a right to testify if you choose to, and that if you want to testify, no one can prevent you from doing so?
Yes, I understand.
You understand that you also have the absolute right not to testify, and that if you don't want to testify, no one can force you to do so?
Yes, I understand.
You understand that you're acting as your own lawyer, so you are required to make this decision on your own behalf. You understand that?
Yes, I understand.
At this point, the next step would be if you have any other witnesses, including yourself, to testify. So I need you to tell me, do you want to testify at your trial or not?
May I ask a question about that, Your Honor?
You can ask a question about it, yes.
How do I testify at the trial for myself? Do I write questions down and give them to you, or
No,
I just?
you just take the stand and then you testify. You state you're placed under oath, and then you say what you want the jury to hear as far as your version of these events, and then the state has the right to cross-examine you.
Okay. I'll testify, Your Honor.
You will.
Yeah, I'll
All
testify.
right. Then we're ready to bring the jury in.
Jury, the state filed a notice of impeachment before trial. It was filed in March of 2023. A copy was given to Mr. Flanagan and Ms. Coffenberry, who were attorneys for the defendant at that time. The same was provided to the defendant when he was mailed discovery. I would ask for the court's ruling on which of those convictions will be admissible to ask him about.
But what day did you file that?
March 23rd, 2023.
You have a copy that you can provide to the court without me having to look through?
I do.
Mr. Vaughn, the state has filed a notice of impeachment and range of punishment as they are permitted to do under the law that states that if you were to testify, they are asking that they be allowed to introduce the following for impeachment purposes: that you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 114 of aggravated assault, a Class C felony, and received a sentence of 3 years on November the 18th of 2016. Second, that you were found guilty in Circuit Court in docket number 2015 CR 134 of evading arrest, a Class C felony, and received a sentence of 2 years. And that was November 18th of 2016. That you were found guilty in the Circuit Court of Dixon County in docket number 2015 CR 199 of aggravated robbery, Class B felony, and received a sentence of 8 years, November the 18th of 2016. That you were found guilty of the Circuit Court of Dixon County in docket number 2015 CR 200 of aggravated robbery of Class B felony, and received a sentence of 8 years, November the 18th of 2016. You were found guilty in the Circuit Court of Dixon County, Tennessee, in docket number 2010 CR 706 of aggravated assault, a Class C felony, and received a sentence of 3 years on July the 15th, 2011. And finally, that you were found guilty in the Circuit Court of Cheatham County in docket number 16001 of failure to appear, a Class E felony, and received a sentence of 2 years on April the 27th, 2010. Those are the offenses that the state intends to cross-examine you about and bring that out, because it is permissible to cross-examine someone on a charge, rather who is testifying, by showing that they have felony convictions. I'll be glad to hear you if you want to argue against the introduction of those.
Yes, Your Honor. The relevance to this case, they have no relevance. I didn't harm anyone. There's nobody physically harmed. As you can see, all them cases are very violent. There was people actually touched in those cases. This is just some he said, she said. That's not the case here. I mean, you know what? Forget all that. How about this? I don't testify. I ain't got more time for this. Let's finish this. I ain't gonna keep going back and forth with y'all. It's just crazy.
The law permits the state to impeach a witness by the introduction, or anyone to impeach a witness by the introduction of felony conviction, so long as those convictions are not related specifically to the type of case that we have here. Having explained to you what the state's intents are, now you have decided, if I understand correctly, and you state under oath that you desire not to testify. Am I correct?
Yeah, ain't no point in it. It's a monkey show, bro. Straight kangaroo court in here.
Vaughn, I have treated you with, let me have another form, please. I've treated you with as much respect as I can do for it as I would any other criminal defendant, even though you're representing yourself. You can make that kind of insulting statement all you want to. It will not change the outcome of this court, nor will it affect this court's ruling on matters that are between, or that are within my, let me have one more. I'm gonna have to quit talking. And this to Mr. Vaughn, this is that waiver of your right to testify. You've been given your right. Is that squiggle line your signature? Is that the only signature you ever use?
You can use it.
I can use it. I don't care if I.
I know you can. You just use the signature I gave you.
Let the record reflect that the defendant has handed to the court a waiver of right to testify, and that he executed that in this courtroom on the 23rd day of October 2025, and that the signature line appears to be just be a squiggly line. It does not bear the same signature as he has on multiple motions that he has filed, but I will accept this as his signature and his waiver of his right to testify. All right, then we are ready to bring the jury back. General Bryson, I'm about to have the final charge printed. Good. And you've got that. Thank you. And I'll give you back. Did you put it in this one? Is this one correct? All right, Mr. Vaughn, do you have any other witnesses you wish to call?
No, that'd be all, Your Honor.
All right, state having rebuttal proof?
No, Judge.
Then we will move to closing arguments. General, you may address the jury.
Judge, I would ask that the victim be allowed to come back in for closing arguments.
All right, she may be allowed to resume presence in the courtroom. General Bryson?
Thank you, Judge. Ladies and gentlemen, thank you for your time and attention on what turned out to be a very long day. You were called in to hear the charges against the defendant of simple assault, false imprisonment, public intoxication, and disorderly conduct. The state presented to you direct evidence, which is the judge gave you in your first jury charge. It's proof of a fact such as the testimony of an eyewitness. And you heard that proof from Bethany Page. This incident was so significant in Miss Page's life and in her work that she called 911 from the store there. She didn't call the non-emergency number. She didn't call her boss. She called 911 because she was afraid of what would happen. She told you that between the defendant's shouting, his waving his arms, his pulling his hands back as if he might hit her, his actual statement that he was going to beat her up, that she was afraid. That is charged under Tennessee law as a simple assault. So to give you a bit of a legal background, once upon a time, assault and battery were two separate offenses in the state of Tennessee. Assault being the fear that someone would hit you, and battery being someone actually hitting you. Tennessee has charged that under one statute, which is simple assault. And the state is proceeding under the theory that she was threatened, that she felt threatened, she felt like she could be hit, she felt like she was in danger of imminent bodily injury. So if someone is to call over the phone and say, I'm going to hit you, there is no imminence. They can't do it immediately. Mr. Vaughn was across the counter from Bethany Page when he told her he was going to beat her. And he made drawbacks as if he might. It was during that time customers came in back and forth. He would calm down and then ramp back up, continuing to yell at Miss Page, continuing to call her names, continuing to make a scene in the store. And I need that other. Let's talk about the disorderly conduct. So the court is going to read you the law on that. And one element, the first element, is that the defendant was in a public place. The Exxon is a place that is open to the public. Now, why this is charged in addition to the simple assault is because the effect of the behavior on the public around. When you commit an assault in the public, it can qualify also as that disorderly conduct. So the defendant was in a public place with intent to cause public alarm or public annoyance, and he engaged in fighting or violent or threatening behavior. And he acted either intentionally, knowingly, or recklessly. Those are the elements that you have to find the disorderly conduct charge. Okay? So we've presented proof that while in a public place, the defendant was not only saying he was going to hit Miss Page, he was acting as though he was going to hit Miss Page. Now, as for the public intox, witnesses testified that they could smell the odor of an alcoholic beverage on him, and Miss Page testified specifically that she remembered seeing his bloodshot eyes. Public intox, it is not a crime to smell like alcohol in a public place. You combine that with the rest of his behavior, that the defendant was under the influence to a degree that either the defendant may have been endangered, he may have been endangering others, other people or property, or that he unreasonably annoyed people in the vicinity. And again, that he was in a public place, acting either intentionally, knowingly, or recklessly. Now, the false imprisonment sounds like he would have had to tie Miss Page up. It is enough that he blocked her path to the exit. There is some testimony that there was another door to the building, that the door was locked. This would be, this would require the victim to jump through hoops, that she would get the key, that she would go unlock the door, that she would take that other path. Where here you have the victim saying that she was trying to see where he was leaving, where he was going, and he was blocking her path to exit. You also have that while she was behind the counter, he kept coming up, blocking her path to exit. She was trapped in that space behind the counter. So you have more than enough proof to find there. You have testimony from the officers indicating that he was still, kind of upset when they got there, even though he had relocated to a different store, didn't like interacting with the officers, didn't want to identify himself, generally just being disagreeable, which is a carryover from his behavior with Miss Page. This is not a homicide case. This is not an aggravated assault case where a weapon was used. But this was still a significant day in the life of Bethany Page, to where she picked up the phone and called 911 because she was in fear for her safety. And you are faced to look at the charges that were put before you and decide if the proof today meets those elements. And if you think that they meet those elements, then I would ask you to return a guilty verdict on all 4 charges. Thank you.
Mr. Vaughn, do you wish to address the jury?
Yes. How y'all doing? Y'all have heard the evidence from the state. You heard evidence from my behalf. Them sound like 2 different stories if you can hear what I'm hearing here today. State is making statements that the woman was blocked behind the counter. I never heard that here today. I've heard that she freely walked me out the door. I also heard the woman state that I was in the store for 10, 15 minutes talking to other people. Doesn't seem like someone too scared right there. I also heard she made a statement of calling 911. It doesn't take 911 10 or 15 minutes to get to Exxon. It's in the middle of town. DTF showed up. Dixon PD showed up. I wasn't even at the scene. Excuse me, I have a piece of paper I want to read to y'all. Let's talk about the false imprisonment. You've heard that the witness state that I blocked her path outside the store where my truck is parked. I don't see that really blocking a path if I'm already parked in front of a store. You also heard the witness say that she locked the door to the other side, and she never did state that she didn't have keys to open that door or had to go get them. If someone's in a store for a while, I don't see any way possible for someone to be harmed. If they wanted to harm them, they can possibly harm them. Let's talk about the public intox. You can blame red eyes on anything. There is no proof that the state can provide Ms. Bethany nor the testifying officer that there was any public intox. There was no breathalyzer test. There was no field sobriety test. There was no blood drawn. No nothing that they can provide other than their statements here today. Let's talk about this public alarm. This is a TCA statute. It's 40-7-103. Grounds for arrest by an officer without a warrant. An officer may, without a warrant, arrest a person for a public offense committed or a breach of the peace threatened in the officer's presence. I've proved here today that nobody was present. There was not an officer present. There was just me and Miss Bethany in the store. It's firstly my word versus hers. She has no witnesses on her side to back her statement. I have no witnesses on the side to back mine. It's he said, she said, like I told y'all from the beginning. If I went all the way to Advanced Auto Parts store. If I really wanted to harm someone, I believe that was in my well means to do so. Standing in the store for 15 minutes, parked in front of the store for however long that was, and not even a rock throw away at the Advanced Auto Parts next door. There is no public alarm when the officers didn't witness it. There is no public intox when you have no proof to provide that there was intox. There is no false imprisonment standing outside of a door. There is no assault when I'm standing in a store talking to someone, as the victim themselves stated I was, and then freely of my own will leave the store. And just, it's the fact that the memories of everybody, from the officers to all the witnesses here today, are not They're very vague. 3 years is a long enough time for anybody. To actually believe that these charges I should be found guilty of, I believe there's enough evidence to believe that I shouldn't. And I want to thank y'all. Have a good day.
Bryson, you have the final say.
I'll waive rebuttal clause, Judge.
All right, ladies and gentlemen, then it's time for me to charge you and give you your final set of instructions. We will pass that to the jury. All right, ladies and gentlemen, this will be the final charge of the court. Ladies and gentlemen of the jury, the defendant, Shereek Vaughn, is charged in the indictment in count 1 with the crime of assault. In count 2, the defendant is charged with false imprisonment. In count 3, the defendant is charged with disorderly conduct. In count 4, the defendant is charged with public intoxication. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dickson County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dickson County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. As heretofore stated, in count 1, the defendant is charged with the crime of assault. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused another to be in reasonable fear of imminent bodily injury. 2, that the defendant acted either intentionally or knowingly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. If you find the defendant guilty of assault as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated, in count 2, the defendant is charged with the crime of false imprisonment. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, that the defendant acted knowingly. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific time period of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of assault as charged in count 1. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of a separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective. And F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find by a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged assault and was not essentially as incidental to it, you must find the defendant not guilty of false imprisonment. Force means compulsion by the use of physical power or violence. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of false imprisonment as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 3. As heretofore stated, in count 3, the defendant is charged with the crime of disorderly conduct. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was in a public place and with the intent to cause public alarm or public annoyance. And 2, that the defendant engaged in fighting or in violent behavior or threatening behavior. 3, that the defendant acted either intentionally, knowingly, or recklessly. Public place means a place to which the public or a group of persons has access and includes but is not limited to highways, transportation facilities, schools, places of amusement, parks, places of business, playgrounds and hallways, lobbies, and other portions of apartment houses and hotels not constituting rooms or apartments designed for actual residence. An act is deemed to occur in a public place if it produces the prescribed or offensive consequences in a public place. Intentionally and knowingly have been defined in count 1. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. If you find the defendant guilty of disorderly conduct as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense and proceed to count 4. As heretofore stated, in count 4, the defendant is charged with the crime of public intoxication. Were you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was under the influence of an intoxicating substance, and 2, that the defendant was under the influence to the degree that the defendant may have been endangered, that there was endangerment to other persons or property, or the defendant unreasonably annoyed people in the vicinity, and that the defendant was in a public place, that the defendant acted either intentionally, knowingly, or recklessly. Public place, intentionally, knowingly, and recklessly have already been defined. If you find the defendant guilty of public intoxication, as charged in the indictment, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as a foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom and your foreman or forelady will announce it. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. Now, ladies and gentlemen, I have prepared a verdict form which deals with each count and provides, for example, in count 1 in the indictment for the charge of assault, we, the jury, found the defendant, Shereek Vaughn, either not guilty or guilty, and you check one, and this foreman or forelady signs it, and that's for each of the 4 counts. It'll help you in your deliberations. Now, before you retire to begin your deliberations, I must select the alternate who will be excused from further participation. You are excused with our thanks. You can wait around and see what your fellow jurors decided in the case, or you may be on your way. The rest of you, if you will let him excuse himself from and you can go out through this door and down through the hallway. Do you have anything in the jury room? Yeah, that'll be through the clerk's office. That they can take you out through a different way. Ladies and gentlemen, you are free to now go across to the jury room and begin your deliberations, and let us know if you're able to reach a verdict. Court stands in recess pending the return of the honorable jury. All right, we are ready to bring the defendant out, please. All right, I'm told that the jury has reached a verdict, but before we bring them back, I was handed, after the jury had been charged and had retired to deliberate, I was handed a motion to dismiss that Mr. Vaughn has filed. And for the record, I will state what the motion says. I, Shereek Vaughn, come before the courts affirming the foregoing to be true, and to the best of my knowledge, paragraph 1, I move to dismiss this case for the witnesses, both the officer and Bethany Page, watching the entire processings and verified it, the fairness in having witnesses prepped while my witnesses are without help to remember is prejudice against the defense. Number 2, the state did not give proper notice of their witnesses in chief until a week before trial. Number 3, a false arrest against the Fourth Amendment is Tennessee statute. The officer did not witness any of this, so no public alarm or threat between Advanced Auto Parts store and the Exxon. 4, none of the witnesses' testimony are fresh and believable. My prayer is for the courts to uphold the Constitution and admit this is illegal and dismiss with prejudice. Mr. Vaughn, do you have anything else that you wish to add to that argument other than what's been stated?
Nothing I can prove, Your Honor.
All right. State wish to make any sort of response to this motion?
Yes, Judge. First of all, the officer, as we've stated, was designated as the state's designee to be seated at the table throughout the proceedings. Ms. Page was not in the courtroom at any time other than her own testimony and the closing argument, which was after the close of proof. We have previously discussed, and you have ruled on the state's proper notice. Both witnesses that testify, names were clearly listed in discovery, Ms. Page being the victim and the officer that testified being the author of the report. I'm not entirely sure what number 3 is. Number 4 is a question of fact for the jury.
I am treating this as a motion for judgment of acquittal since it was filed after the close of the state's proof. Whether I treat it as a motion to dismiss or a motion for judgment of acquittal, since we're at the trial stage, I will deal with each of his issues that he has raised. And number 1, he moves to dismiss for the witnesses, officer and Bethany Page, watching the entire proceedings. And I find, as I have already dealt with the officer being the designated legal representative of law enforcement, that the rule does not apply to that individual. And for that reason, Officer Clark would be allowed to remain in the courtroom. Number 2, there's no evidence whatsoever that Bethany Page watched the trial proceedings. The only evidence was that she may have watched part of this morning's motion hearing, which are 2 completely different proceedings, and therefore the rule was not imposed upon her because she was not a witness. So issue number 1 is denied. Two, the state did not give proper notice of the witnesses in chief until a week before. I have ruled on that prior to trial. Ruled on it this morning. Therefore, this motion number 2 is denied. Number 3, a false arrest against the Fourth Amendment. And we have also dealt with that same issue this morning in his motion to quash or dismiss, and I stand on the ruling that I made at that point. Number 4, none of the witnesses' testimony was fresh or believable is a jury issue. Being fresh testimony is not a standard that I'm aware of ever has been applied to anything in a courtroom. So as a result of that, I find that there are none of these bases that have been raised by the defendant in this motion to dismiss are valid, and therefore I deny the motion. You ready to bring it?
Your Honor, I gave you a note earlier today. Would you make a rule on that right quick?
A rule, you gave me a note that said,
Yeah.
please don't dismiss Jennifer to preserve statement for a violation in another case. I don't know what that means.
I didn't have time because I was trying to focus on this, but it was a motion. I need to file a motion to preserve testimony for a violation she witnessed herself in the last case we had here, Your Honor.
Well, I have no authority to hold her, for any reason. So, you can file something and have a hearing set and subpoena her, but as far as me holding someone, she's not under arrest and she's under a subpoena, but that concludes at the end of this trial. So for that reason, your request to hold her to preserve a statement is not something that I
Was she dismissed already, Your Honor?
don't know whether she's gone or not. So. But your request for this court to order that she be held there's no legal basis for doing so. All right, bring the jury out, please. Ladies and gentlemen, I'm told that you have been able to reach a verdict. Is that correct? All right, are you the foreman? All right, let me go over this form with you, and we'll go over this together. As to count 1 of the indictment in the charge of assault, how does the jury find the defendant? Guilty or not guilty? Not guilty. As to the charge, count 2 of the indictment, the charge of false imprisonment, how does the jury find the defendant? Not guilty or guilty? As to count 3 of the indictment on the charge of false imprisonment, I'm sorry, that was a false imprisonment. As to count 3, the charge of disorderly conduct, how does the jury find guilty or not guilty? And as to not guilty, and as to count 4, charge of public intoxication, how does you find guilty or not guilty? So all 4 counts, the jury is unanimous in its finding not guilty. All right, then thank you for your time, and you are free to go until 6 o'clock Monday night when you need to check that number to determine whether or not we need you for the trials on Tuesday. Thank you. I wish I could tell you don't have to come back. So.
Yes, you did.
All right, Mr. Vaughn, the jury has found you not guilty of these 4 counts. That leaves us with 2 other charges. I think that 2 other indictments that still need to be dealt with. So he has a driving on revoked license, 3rd offense that he withdrew his guilty plea on, and we need to set that for a trial. Do you have an idea of when you want to try that, General?
Let me go ahead and get my other files up. I'm going to go ahead and on 2021 CR 462, that is the case with the aggravated assaults, reckless endangerment, and felon in possession of a weapon. State is going to enter a nollie on that after discussion with the victims.
All right.
That will leave us one case to set. I would like.
And that is the driving on a revoked license, correct?
Yes.
All right.
I would like, I've not had a chance to talk to one of the THP representatives about his driving history. Could we set well, you have to give us a date. Or could we set it in front of Judge Wallace for him to?
Oh, I'm sure Mr. Vaughn would probably prefer to have a different judge anyway. So.
No, I like fighting with you.
No. I'm not saying for Judge Wallace to take the trial because you already heard the first half of it. But could you give me a little bit to make a decision on whether the state's going to go forward or let that one go as well?
Your Honor, would that be new witness evidence she's providing? She's talking about she need to get a hold of THP?
Nope, you have a copy of it. It's just a person I need to talk to clarify something.
All right. So what are you asking to do about that? We've nollied the one case that you have a victim problem with, and now we're down to the driving on a revoked license third offense. What are you wanting to do about scheduling? You wanting to put it on a date for Judge Wallace to consider setting a date?
I tell you what, Judge, could we, I know you're back for the Godwin case. Would you want to pick a date that morning before trial or?
As far as I'm concerned, you're talking about on Tuesday, the 28th?
No, I'm talking about November the 6th. I have Cordarius Godwin.
Oh, I forgot.
Yes, you scheduled that.
Cordarius Godwin is set on the 6th of November. I don't have a problem with it. 8:30 in the morning, we'll consider whether we'll have Mr. Vaughn here and we'll meet.
What you say, November 26th?
November the 6th.
November 6th at 8:30 a.m. we'll have a hearing, a status hearing to determine on the driving on revoked license what you're planning to do, and we'll set a trial date at that point.
You know what, Your Honor? Do I need to put in a motion to, never mind, Your Honor, never mind.
All right, then we stand adjourned.
You'll have a whole lot of time to think.
Well, guys, we have come to the end of part 2 of the second trial for Mr. Shereek Vaughn. And I must say, definitely surprising. Well, I don't want to say surprising because I wasn't really surprised of the outcome of the verdict of him being found not guilty, because I think that there was a lot of things, and I mentioned this in the first part of the trial, in the first video, that a lot of things wasn't lining up. There was a lot of things that you can poke holes into. Even the young lady, Bethany, that testified, just by her testimony, even her attitude, her personality. I'm not saying that because of her personality and her attitude that she couldn't be scared, but just by some of the things that she said she did herself, it didn't really sound like somebody that was really in a whole lot of fear. And then you hear the testimony from his kid's mother about her following him outside after the fact. And that's what I said in the first video when the prosecutor, and she did it again this part of the trial, where she tried to make it like he was possibly blocking her from getting out. A lot of it just didn't make sense, and the state obviously didn't meet the burden of their proof. That they didn't prove that without beyond a reasonable doubt that he was guilty. And like I said, it was just so many different things to poke holes into. And I must say, Mr. Vaughn did a good job in asking some of the right questions. He definitely had a lot of ums and uhs in there, but for the most part, he asked the right questions. I thought he had blew his chances when he kind of blew up and got offended. But then I remember when the jury came back, like, oh, the jury They're not in there, so they don't even see this, but he was ready to take the stand. But when they, was ready to bring back his past and some of the things he had done, he was like, no way, Jose, I'm not gonna allow that. But you saw he got very offended, started calling it a clown show and circus. And respect to Judge Wolf, because I agree, definitely Mr. Vaughn had been treated with respect. Judge Wolf has been fair through the whole entire trial. And I get it. He was a little frustrated because they're bringing up his past, but this is the game, that you're playing. This is what court is about. They're going to try to use whatever they can to make their point, and they encourage you to do the same, to defend yourself. But they are the ones that have to prove that you are guilty beyond a reasonable doubt, and by any means, they're going to try to do that. But listen, we are here at the end of our trial. We got some more trials coming up, some more interesting trials with a lot more, because Mr. Vaughn, he didn't go into a lot of the sovereign citizen stuff he went into in his regular proceedings, but we got some trials coming up where they're going to be still going full-fledged with the sovereign citizen stuff. So just stay tuned for that, guys. As always, thank you for joining me here at Sovereign Citizens Hall of Fame. I thank you for joining me on these trials, being able to sit in and listen to something and learn something, because I've learned a lot just listening to both of Mr. Vaughn's trials. And I like this type of atmosphere, right? I know I'm talking a lot. I'm about to get out of here, but I like this, like, not to only share when these guys are kind of going off the rails and just saying anything. Some of them, because they might be going through in their mind. Some of them, they're just scheming, trying to prolong, the cases, and then some just 100% believe some of this stuff that they're saying. But I like to sit down and just go through the trial and just see the process of it and just see how it all plays out, especially with people that we've either covered or that are sovereign citizens. But okay, that's it. This is Sovereign Citizens Hall of Fame. Don't forget to like, share, comment, subscribe. And for now, guys, Sovereign Citizens Court is adjourned. I'll catch you guys on the next video. Thank you, and God bless.